there is a ship, a supply ship, that is operational, on time and under budget, thanks in part to Vice Admiral Norman. I think it's time to say sorry to him.
For the Rebel.media, I'm Ezra Levant. I'm standing about a block away from the Ottawa courthouse, and I'm outside the HMCS Bytown Officers' Mess. It's basically the Naval Club here in town, where shortly Vice Admiral Mark Norman and his lawyer Marie Henein will have a press conference discussing their great legal victory this morning over the prosecution against Mark Norman for one count of breach of trust. You may know that Mark Norman was charged with this after he blew the whistle on Justin Trudeau's Liberal plan to move a shipbuilding contract from a Quebec firm to a Liberal-connected firm, the Irving Shipyards in the Atlantic, that would cost Canadian taxpayers $89 million to break the contract with the Quebec firm. And of course, it did not meet the original bid. So this was pure political machinations on the part of the Liberals. Vice Admiral Mark Norman mentioned this to the Quebec shipyard and perhaps others, and was prosecuted for a crime generally reserved for those who engage in some sort of personal corruption or even treason. In fact, he was an honest, good faith whistleblower. It was the Liberals who were corrupting the process. Interestingly, a few days ago, Andrew Leslie, the retired general in the Canadian Armed Forces who sits as a Liberal MP, made it be known that he would actually testify on behalf of Vice Admiral Norman, and that this trial would happen shortly before the 2019 election. Well, wouldn't you know it, today the prosecution dropped the case against Mark Norman, saying new evidence had come to light. Yeah, I'm sure. Well, we're about to go in for the press conference, so I'll have more from you from there.
Ultimately, I look forward to my immediate reinstatement and a return to serve in Canada, something that I have done unfailingly for the last 38 years, something that Canadians should expect and demand. In closing, I want to speak directly to the thousands of Canadians who stood by me, who supported me and my family, both spiritually and financially. We would simply have never made it here without your generosity and help. Thank you.
And just before we begin, I do want to introduce again the all-female team that represented Vice Admiral Mark Norman. Sydney Hopkins at the end, Maya Baroa, and my co-counsel Christine Manville. Fortunately, Vice Admiral Norman didn't fire the females that he hired. So we're ready to take questions from you. Yeah.
For 2 years or more, you've had this stigma of these criminal charges against you, but the exculpatory information is not known. Why should it be known? How can we find out what it was that set you free?
Well, that's in the hands of the prosecution, and as you know, there is another prosecution that is outstanding. So the Crown has all sorts of obligations in respect of that. It is sitting with them. As you know, we were in the midst of a third party viewing them. We've been on month 5 or 6 of that exercise. And as this matter ends today, that means our involvement in the process, as well as our ability to compel production, ends with it as well. So it is now in the hands of the people who are the holder of those records.
Ms. Hannon, do you believe that, do you have any evidence that this prosecution initially, or at least the decision to stay it, was politically motivated in any way?
Well, there are a number of questions here, so let me break it up for a moment. The decision to stay this prosecution was discretion exercised by the prosecutors and the DPP, unimpacted by any political considerations, as it should be. That is, in fact, how things are supposed to work. Politics are supposed to stay out of the prosecutorial process. But I would remind you that in this case, the government has been at the table, and they've been at the table. They've been represented by 7 or 8 lawyers in court at the Department of Justice. So these charges were referred by the PCO, the Privy Council Office. The PCO has been the holder of the records that we've now spent 6 months trying to get, and to this day, Vice Admiral Norman, because of the position taken by the PMO and PCO's office, has not had access to his own records, and we were continuing in this fight. So they have had a seat at the table, they have been participants in the process, they have been represented. So much so that they are not only the people who decided whether or not to assert cabinet confidence and then a last-minute switch to public interest privilege, and are not only the holders of the documents, but were also counseling witnesses as to what they could and could not say. And I want to make it very clear that we, the defense, had to bring this motion at great expense to Vice Admiral Norman to get at those records. Neither we, and here's the important part, nor the prosecution were given access to those documents. And the people that were standing in the way of that full disclosure is obviously the government, who had access to them, had those third-party records, and was taking the positions that you all heard they were taking in court.
So you presented information to the Crown that they had not seen before?
Correct. That is
And
correct.
what was their reaction? I mean, this investigation went on for 2 years.
Well, that's right. It did go on for 2 years, and one of the things that we've said in court is that during the course of the investigation, although the information covered a significant part of the Harper government time period, there were no witnesses interviewed from that time period. You recall that in court we produced the consent of former Prime Minister Harper to release all the documents, despite our repeated requests that request be made by the PCO. So
was that information suppressed? Was it suppressed by the RCMP?
no, the RCMP didn't have it, or didn't look for it. I don't think they were suppressing anything. I think the full picture of how these very complicated contracts are in fact negotiated, and what the life of this particular contract was far more complicated, far more sophisticated, and was not completely looked at. But as I said at the outset, we brought a third-party records application for a reason. It was to get precisely at those documents that were in the hands of various government bodies, the PCO, the DND, I mean, you name it. None of that came willingly. We have been, and you have all been with us for 6 months as we have tried day in and day out to try to get that material. It should have been handed over. It should have been handed over to the RCMP. It should have been handed over to the prosecution. It was not.
Do you want an apology from anyone in particular in government in this? And most notably, do you want an apology from Prime Minister Justin Trudeau for how he has commented on the case?
Well, he's commented a number of times on this case, as you know, before it ever went into court. And as we now know, after our application for third-party records was filed, there were numerous comments made from the PCO, anonymous sources, and the Treasury Board, anonymous sources, responding to our application that was proceeding in a court. A bit of an extraordinary event. I've certainly never seen that occur. So to say there was an interest in this case puts it mildly. Vice Admiral Norman has been through a great deal. His family has been through a great deal. There is a ship, a supply ship, that is operational, on time and under budget, thanks in part to Vice Admiral Norman. I think it's time to say sorry to him.
I think some people who have been involved in this need to reflect on what happened and why it happened and their role in that.
I think they should be concerned when there are attempts to bring the political into a criminal courtroom. And I think they should feel very proud and very happy today because what they saw is that our justice system is truly unassailable. The prosecutors in a high-profile case looked at the evidence and did what they're supposed to do. They said, we don't have a reasonable prospect of conviction. The DPP acted independently. If it tells you anything, it tells you that when she thinks you should prosecute, she goes ahead, and when she thinks you shouldn't, she declines to do so. That's the way it should be. No person in this country should ever walk into a courtroom and feel like they are fighting their elected government or any sort of political factors at all. You should be very concerned when anyone tries to erode the resilience of the justice system or demonstrates a failure to understand why it is so fundamental to the democratic values that we hold so dear. There are times you agree with what happens in a court, there are times you don't, and that's fine. But what you don't do is you don't put your finger and try to weigh in on the scales of justice.
One of the hardest parts on an emotional level, although it was inspiring, was to receive letters and donations from World War II veterans giving me $5 to help my legal fees. Just a second. At the other end of the spectrum, the hardest part is watching my family have to live with this on a day-to-day basis.
A few minutes ago, the defense minister said the government will be covering your legal fees. Can you respond to that?
Oh, is the response. That's,
Wow.
yeah.
Okay.
Next question.
What's the timeline between when you gave this information to the prosecution and they made the decision to not proceed?
As Ms. Mercier indicated, it was towards the end of March that they received the documents, and we met with them, and then they conduct, as they do anytime that you provide information to the prosecution, you expect it to be tested, and they conduct a review of it, and they do other interviews, and so that was the time.
You're
It's
pleased
been
with
over a
that?
month.
Are you pleased with the pace and the seriousness that they
Well,
treated that?
they moved very quickly. I mean, they moved in a very responsive manner when they received the information, and it's not the first time, as you know, that I've provided information to the prosecution and asked them to objectively review it, which should give you a good clue as to what my faith is generally in the prosecution. Well, they were free from political interference. The problem was, I gather, that other people had to pay the price to protect that institution. That was the entire point, as I understand it, was the concern that there was an attempt at interference that was resisted. I don't know if there was an attempt or not. It's not for me to make that determination. But I think what you see in both of these cases is that people that are involved in the justice system resist any sort of external inappropriate influences. That we know that the justice system has to stand apart and entirely insulated from any other sorts of considerations.
Well, I just got out of that press conference with Vice Admiral Mark Norman and his lawyer Marie Henein. He says he's eager to get back to work and thinks he will be. He says he doesn't care about the bad blood. He says he's worked with different politicians of different stripes before, and he's loyal to the country. I believe that he is. It was interesting. Marie Henein said it is within the power of the government to release to the public the exculpatory evidence that let Mark Norman go, and I think they should. Marie Henein was scathing in her comments about Justin Trudeau, and not only his corruption of justice, but frankly, his treatment of women. That was a funny joke. Of course, Mark Norman's team of lawyers was all female. Henein pointed out Trudeau doesn't do that anymore. Henein did leave me with the strong sense that the prosecutor actually wasn't the bad guy here, and that when she had in her hand information that was hidden from her, from Justin Trudeau, she fairly speedily did the right thing, and I accept her view on that. We also learned in that press conference that the government of Canada has indeed chosen late in the day to pay Mark Norman's legal fees. I think he should go much further. I think he should sue Justin Trudeau and the government for abuse of process and abuse of office, because they clearly perverted the course of justice to try and get a political enemy. There is no doubt about it. Justin Trudeau used the courts and the prosecutors to get a political enemy, and this trial would have been devastating to him had it happened on the eve of the election. But now Trudeau is embarrassed by this acquittal, essentially, the staying of the charges. Mark Norman is vindicated, and I suppose the reputation of Canada's courts remains intact despite Trudeau's worst efforts. For the Rebel.Media, reporting from Ottawa, this is Ezra Levant.